So a lot of the attention always goes to major leagues and the major league teams, but especially in baseball, you have a deep minor league system. And recently, some players and attorneys have started to call attention to some problems with the minor league system. Do you want to talk us through about some of these issues that have been percolating?
Sure. Sure. Well, right here at Miami, we had a whole panel on this. Garrett Brosius brought a class action. It's called the Senni case. He was a former minor league player who became a lawyer and brought this class action on an hourly rate. Let's call it Fair Labor Standards Act. In other words, minor leaguers aren't being paid the minimum wage. When you add up all the hours they're required to work pursuant to their contract with their major league parent, and you divide that by how much they're paid, it doesn't amount to hourly wage rate. So this was a class action, a putative class action, to break it down. The class certification hearing was held, and class certification was denied on the theory that, well, each of these minor league players, yes, maybe they have a case for being underpaid, but each case is different, so we can't really give it class treatment. Now, as we speak, that's being reconsidered. So perhaps it'll be able to be pursued on a class basis. But for those who don't know, every minor league team is affiliated with a parent. Okay, and each parent club in each of the 30 clubs has 6, 7 minor league teams. So when you do the math, at the A level, maybe $1,200 a month, double A, $2,000 a month, the rough math, and they're essentially working year-round on a contract with their major league parent, as long as they're an affiliated ball. It really isn't until they break through to AAA that they're making, serious money. So the vast majority of this huge pyramid in the minor league system that gets built up will never see a day of major league service. The vast majority will not. So this is their last chance to break through and get the major league minimum. Otherwise, they've worked a long time for not much pay.
And what struck me when I first read about this case in particular is what gets so much attention in professional sports is these large contracts that you see on the front pages, and it wouldn't even occur to the average, I think, fan or even myself to start calculating the hourly rate of what these players, because the numbers are just so astronomical. But when you really do look at these minor leaguers and in the system, it really made me stop and think, wow, what's going on here?
Let's just do the pyramid: A, double A, triple A. There's going to be 30 to 40 at each of those levels, and maybe 6 to 10 will make it to the majors, and to get even to the major league minimum, maybe 4 in that pyramid for any major league team. So when you get right down to it now, there's also an exemption that's being sought in Congress. So again, you ask, what does it take to be a sports lawyer? You've got to be able to lobby. So there's a lobby trying to classify minor leaguers, and this is the way they've been treated, as seasonal employees, seasonal, which then would be an exemption. Minor league baseball is taking the position they are seasonal, and therefore they don't have to be paid minimum wage. That they're looking for Congress to make that permanent, a permanent legislative action. They're still proceeding as if that is the case. So that's the other part of Garrett Brosius' challenge. So again, to be a sports lawyer, you got to know a lot of things. You got to be able to network, and you got to be able to work Capitol Hill a little bit too.
Sure. And what's your prediction on kind of where this goes out, where this leads?
Good question. Well, right now Congress is not going to do anything anytime soon. Although minor leagues. My prediction, there will be joinder of similarly situated minor leaguers, that subclasses can and will be created ultimately. Not a master class, but subclasses of similarly situated, I'm just throwing this out, double A guys, triple A guys, single A guys who could pursue similarly situated claims on a joinder basis, but not on a master class basis. That could well happen. I think then for sure minor league baseball try to get ahead of it by getting them classed as seasonal employees.
And there have been some analogous cases, I believe, with cheerleaders.
Absolutely.
In
Absolutely.
Sports, right?
Yes, absolutely. We were out at Dolphins Stadium, well, not Hard Rock Stadium today, and yes, cheerleaders are making the same case that their stipends, their honoraria, that they are paid are not sufficient for the hours they're required to work.
Right, sure. Well, this is going to be an area to watch.
Yeah, and let me just add, there's also another aspect to this, that there's a baseball antitrust exemption. So there could still be a challenge on restraint of trade grounds, which would be a straight antitrust case, assuming the Fair Labor Standards Act case didn't hold up. So watch this space.
Yeah.